Welcome back, ladies and gentlemen. And Mr. Bradsher, further questions for this witness?
Just a couple, Your Honor. Judge Stultz, did you give any other interview concerning your recollection of these events other than talking with Agent Whitley on September 9th?
No.
Okay. Were you given an opportunity to look back at your statement prior to testimony today?
No. Well, look at that statement prior to today?
Yes.
Yes, I did have an opportunity to look at it.
Okay. Just a couple of questions on that. Do you recall that you indicated that you thought the first indication that you had from me about this issue of whether or not Cindy was working the hours she was putting in Beacon was by phone call?
No.
Okay. As you sit here today, you are testifying as you recall it. Is that right?
Yes.
Okay. And in terms of the calling Miss Peed to ask her if she's putting it in Beacon, do you think you did that the same night that you relayed to the prosecutor, the night where you were called and you were at this event?
Yes.
Okay. And in terms of, I had asked you about seeing Cindy Blitzer in her office in Rockingham. Do you recall telling the SBI agent that you did see her and knew where her office was through June of 2015?
I told the SBI agent that I had been over there several times. I saw the office on several occasions. I did not physically see her.
Okay.
And that is different than what that statement says. But that was I did not go back and talk to Agent Whitley about those sorts of things at any point afterwards.
Okay. And you've described for the jury sporadic interaction with Ms. Blitzer over the year and a half she was employed by 9A. I want to ask you one other question. As Person County Chief during the first 4 years, did you have direct contact working with Pam Bradsher?
Yes.
And could you just briefly describe for the jury your interaction with her and her work ethic?
Pam was a victim witness legal assistant for our office. I worked closely with her for grand jury preparation and spent large volumes of time with her.
And was she a hard worker?
I never had any complaint with Ms. Bradsher.
All right. Continue the witness, Your Honor.
Redirect.
Yes, very briefly. Judge, we talked a little bit about some of the tasks that Cindy Blitzer had or that you were aware of while she was employed there, right?
Yes.
And you said something about special projects.
Yes.
Do you recall, and I believe you said that you heard that from the defendant?
Yes.
Do you recall when would have been the first time you heard that phraseology of special projects?
It would have been after, I believe, that I talked with Agent Whitley.
Okay. Before then, had you heard that specific term of special projects?
I don't believe so.
No further questions.
Mr. Bradsher.
Just to follow up on that, in the context of me giving work for Cindy to do prior to talking to Agent Whitley, were you aware of any of that?
The only thing I was aware that I had told her to work on Shockley, and you had other things that she had to work on.
All right. So in terms of me representing to you that I have given her work to do prior to you talking to Agent Whitley, had I represented that to you?
Yes, I believe you had.
Thank you. Nothing further.
All right. Thank you, sir. You may step down.
Thank you.
Further evidence for the state?
May we approach?
Yes. Jury, there's a matter I need to take up with counsel outside the presence of the jury, so I'm going to ask you to step in the deliberation room. Please leave your notepads in your chairs. Recall all the instructions I've given you. All right, outside the presence of the jury, I understand now would be a good time to talk about that State's Exhibit number 15. Is that correct?
Yes, Your Honor.
Telephone records. Mr. Bradsher, what's your objection to the admission of those records?
May I approach the exhibit, Your Honor?
Yes, sir.
Okay. And this is the sum total of your offer,
Yes.
and it's forecast that you're going to rest. With those circumstances, I don't object.
Okay, then 15's admitted. Any other exhibits? Have you conferred with the clerk about any further exhibits?
I have not. I believe I have introduced every exhibit except with this introduction. I have introduced every exhibit except number 12 and 13, which would have been interviews of Tyler Henderson and an interview of Craig Blitzer, which were used for refreshing memories, and I did not move to introduce either of those documents, but I believe states 1 through 15, excluding those two, would have been moved to introduce. If I have not already done so, would move to do so again.
All right.
No objection.
Okay, so those, to the extent they've not been admitted, are allowed. All right, and is state resting at this stage?
Yes, Your Honor.
All right, very good. So at this stage, outside the presence of the jury, the state having rested, a couple things I'd like to do. Entertain any motions that are to be made at this stage of the proceedings. Also would want to take a moment, Mr. Bradsher, just to discuss with you a decision as to whether you will testify or not and the implications of that decision.
Yes, Your Honor. I guess my request, Your Honor, and I know that the court's time is valuable, but given the complexity of the case, and I'm a little bit surprised that we're ending today, given the list of witnesses, I would like an opportunity to prepare a brief on the issues to present in the morning, if you will allow. Again, it's a unique set of circumstances where we're talking about 3 obtaining property by false pretense related offenses with regards to state salary and potentially benefits. And then we have 3 other separate obstruction charges which are not as complicated in terms of to make the argument. In terms of the decision to testify or not testify, that is also something I'd like an opportunity to, now that the state is rested, and I think the state would agree, there was no forecast to me that it was going to end here, and I know that happens in trials, but I would like to assess the witnesses that have been presented and tell the court the decision in the morning, if that is possible. I do and will forecast to the court that based on my initial evaluation of the state's case, that we will not have evidence to exceed a week. And I will try to, and I've been working with various representatives of witnesses to try to consolidate and pare those down. So with that forecast, I hope the court will consider giving me the opportunity to make a motion, the motions to dismiss that would be customary at the end of state's evidence in the morning with a brief, if you'll allow me to.
Well, let me ask this. Do you have witnesses that are prepared to start now?
No, Your Honor. I was not anticipating evidence today. Again, with the length of the state's witness list, I'm a little bit surprised, but as I'm sure the court is, thankful to hear that that part's over and that my part will not exceed a week.
All right. Well, that puts me in sort of a dilemma because, I mean, I need to conduct this trial efficiently for the sake of everyone involved, and not the least of which being the jurors who we have promised them to use their time efficiently, and I'm very reluctant to take breaks in the action under these circumstances. I certainly don't have a problem hearing further arguments on a motion to dismiss, and of course, as you know, that there is a virtually identical motion that's made at the close of all the evidence, but
And I will, to try and advocate for my position, Your Honor, I was judicious in the length of cross-examination with this what has now been known as the state's last witness. And I do know we're already in the afternoon, and I would ask the court to consider this hour and a half or 2 hours as not being wasteful of the court's time, but helpful in resolving the issue.
Well, I'm not sure I have a choice. I mean, if you don't have witnesses ready to go, and I can tell you I'm not going to allocate very much time to hearing motions tomorrow morning. I mean, that at a minimum, I think it's a reasonable expectation that if you have a motion that you want heard, that we hear that today. And if you want to supplement it with the brief, that's fine. But I think we, at a minimum, ought to hear any motions that you have. As far as starting with the defense's evidence tomorrow, we'll do that at 9:30. As you recall, the schedule gets a little choppy for the next couple weeks, and that's part of my reluctance to lose time. I mean, we have 2.5 hours this afternoon that we should be using. We're not having court on Friday due to prior commitment I have in a homicide case in Durham County. We're not having court next Thursday or Friday due to the Superior Court Judges Conference that I have commitments at. So we're, even with a week forecast of evidence, we're looking at moving effectively into the week of June the 25th. So I imagine that's still, if that's your forecast, that between now, with the remainder of this week, we have 2 trial days left in this week, 2 trial dates left in the following, or 3 trial dates left in the following week. What I'm hearing you saying is that we may well be in a position, and this is assuming no motions are granted and that we're just moving forward on all charges for the sake of planning. I'm assuming what you're saying is that we're likely to get this to a jury in the very early part of the week of the 25th. Is that what you're committing to?
Yes, Your Honor. In fact, absent some conflict that the Attorney General's office asserts for a witness, I certainly plan to have my evidence finished by next Wednesday. Because in addition to the substance, I do think from a realistic standpoint of holding the jury's attention that it would be not helpful to break up the evidence again over that 2-day break. So my goal is to get all of that in by 5 o'clock on next Wednesday.
Well, I think that's a reasonable goal, and it would put us in a position where Monday morning the following week we could be having closing arguments, charging a jury, and deliberation in that following week. And I think that would be well within the expectation that we gave the jurors at the beginning of the trial. Mr. Latour, do you want to be heard on any of these issues?
The only thing that I'll say, I will concede that I did not tell Mr. Bradsher that I was going to rest. However, I would say to the court that when asked my forecast of this case, I said a week.
Yes, sir.
We're past that now. So we've exceeded the time that I intended to present evidence, and so that I would contend there is at least some notice that we're getting to the point where I indicated that we would be wrapping up. I understand he doesn't have witnesses lined up for this afternoon, and I have no problem with that. I do start sharing the concern, I believe, of the court, and it sounds like Mr. Bradsher, that when we start getting into weeks and we're missing days, and then based on what I know of this case and what I've seen in other things, we've still got a charge conference, which could take quite some time, considering, as he's couched it, that it's complex issues in his opinion. We've got time this afternoon that we can resolve certain things. I understand he may want to make certain decisions about himself, whether he wants to testify or not, but I would contend he at least does have one witness that could be ready to go this afternoon. And yes. So I would ask that we at least resolve the motions this afternoon. If he wants to file something, obviously that's in Your Honor's discretion, but he's had ample time to think through this issue and to know what at least the forecast of the evidence would be, to know what the concerns in the law should be and what my requirements to prove would be. And so I would submit to Your Honor that there's plenty of time to at least resolve a motion to dismiss at the close of state's evidence. And as you indicated, we would certainly hear us. If he's not successful on that, there's certainly a similar argument that can be made at the close of all of the evidence that he would then be able to present any written briefs on those issues, which would obviously not be precluded by whatever argument he makes today.
All right. Okay. I think that's the plan. In my discretion, Mr. Bradsher, I'll allow you to begin your presentation of evidence tomorrow morning at 9:30. I think we will hear the motions today. I'll talk to you about your decision to testify. I don't need a decision on that actually until you take the stand. You don't need to tell us what your decision is, but rather I just need to have the conference with you, make sure you understand the implications of your decision. And then what I'm likely to do is, after listening to your arguments, if you wish to supplement your arguments with a brief, I would receive those early in the morning, probably before 9:30, so that I could read them before court. If there was something we needed to talk about further, then we'd take time to do it. If I'm ready to rule at 9:30, then I'll rule at 9:30.
Yes, Your Honor. Would the court consider, upon release of the jury, to allow me 30 minutes, and then
we can do that.
I will limit my argument to 15 minutes?
Right, that's fine.
Okay.
We can do that. What I'd like to do is bring the jurors back in, I'm going to ask whether there's further evidence. Mr. Latour, if you'll then inform the jurors that the state rests, I'll tell the jurors that we have some matters that will take us a bit longer to resolve, and that we will begin with evidence for the defense. If the defense chooses to present evidence, we'll begin with that at 9:30 in the morning, and that I'll also inform them that based on my conversations, what I'd like to do is predict to them that we are satisfied at this stage that, barring something unforeseen, that at some point during the month of June, we will conclude this matter, so that they can feel a little bit of sense that they have a schedule. So if there's no objection to me letting them know that, I will inform them of that. All right?
Yes, Your Honor.
Yes, Your Honor.
Okay. Let's bring jurors in. Mr. Latour, is there further evidence for the state?
Your Honor, at this time, the state would rest.
All right. So, ladies and gentlemen, this concludes the state's evidence in this case. There continue to be some matters I need to discuss with counsel outside your presence. So what I've elected to do is, if the defense wishes to offer evidence, we'll begin that tomorrow morning at 9:30. But rather than keep you waiting while we go through the matters we need to discuss, we're going to go ahead and allow you to go home for the afternoon and return at 9:30. I've also had an opportunity at this stage to discuss with counsel. Now we have a little better sense of where we are in the proceedings and the time that this matter is taking. I think I can safely say that we will come in, that the matter is likely to be resolved during the month of June. So we will not extend into that week of July 4th or beyond. I know their vacation schedules. So, and you'll recall that, for example, we're closed this Friday for this trial, and then next Thursday and Friday we have no court. So we have the remainder of this week through Thursday, then we have Monday through Wednesday the following week. And even with those days of no court, we do anticipate that this case will be resolved within the month of June. So that's where we are at this stage. So hopefully that gives us a little bit of comfort as to what our schedules are going to look like for the remainder of the next few weeks. Again, we thank you all very much for your service. I'm going to remind you of the rules not to talk about this case with anyone else or allow anyone to talk about it in your presence. Don't talk about it among yourselves. Don't form or express opinions about the outcome. Keep an open mind in these proceedings. No independent investigation, no media, and no conversations with parties, witnesses, or lawyers. Leave your notepads in the chairs. Gather at 9:30 tomorrow morning in the deliberation room. And again, thank you very much for your service. All right. So, Ms. Bradsher, just so I don't neglect to do this, I'm going to talk to you briefly about your decision to testify. Sir, you have a decision. It's a personal decision that you alone must make, and that decision is whether you will testify in this case. If you do choose to testify, there are some consequences that I'm sure you're aware of. The primary consequence is that you will waive your privilege against self-incrimination, which means that you will be required to testify truthfully, both in response to questions that Mr. Latour may ask of you, and also testimony that you may choose to give. And that would be irrespective of the fact as to whether that testimony tended to incriminate you or otherwise was against your interest. I want to make sure, first of all, that you understand what I've explained to you. Do you understand that, sir?
I certainly do, Your Honor.
All right. And I want to make sure that you have ample time to consider your decision in this case. I'm not going to require that you inform the court of the decision, but just want to make sure that you take the time to reflect on what I've told you before you make your decision in this matter.
Thank you, Your Honor. May I address the court on that issue?
Yes.
As a part of the consideration of that decision, would the court entertain the state's motion with regards to their request that the testimony be given by way of propounded questions versus the narrative? I don't need additional time to prepare, and I do believe it's discretionary with Your Honor. My position to the court, and then I'll yield to the state if I may, as a defendant and as the attorney representing myself, that I do believe federal rules may require such a procedure. I'm not aware of a requirement in North Carolina that it would have to be by propounded questions. And so my position is that I should be allowed to testify in narrative form, subject to being objected to in the court's direction as you have directed us throughout this trial. That's my position, and I would ask the court to, after hearing from the state, at some point give me a ruling on that, and then that will be a factor, Your Honor, in my ultimate decision whether to testify or not.
Well, that's interesting. I, quite frankly, was not aware, or maybe subconsciously was aware of a request by the state, but it's an issue that I actually researched several days ago, just considering it in my own mind. So has the state actually requested that in the pretrial motion?
We have, Your Honor. There was a motion in limine filed before we started, and I believe there were, I want to say, two motions. The first motion was the motion about the pretrial publicity / lawsuit things that Your Honor, ruled on. The second motion, which I mentioned, was, and I said might be more appropriate to wait until we get to this point, is a motion that the state is requesting that the court order the defendant, if he should decide to testify, that he state a question and answer his question. I understand it is unorthodox in what we normally deal with, but we also normally are not dealing with a skilled attorney who is representing himself in this matter. And so he's certainly trained in how to form and structure a question on direct examination. And part of the reason that we have filed that motion is because in dealing with Mr. Bradsher, some other lawyers in our office at the time felt that it would likely be appropriate, and having listened to some of the cross-examination, I think it's certainly something that would shed light and be helpful to the jury, the judge, and the state to be able to ensure what type of evidence is presented to the jury. My concern, and not that he would do anything intentionally to skirt those rules, but that he gets into a discussion about something and is jumping from topic to topic and starts to state things that other people have not stated or things along those lines. And as Your Honor knows, once those statements are out there, it's kind of hard to reel it back in, especially when dealing with a narrative form without any questions to know what the topic will be, to be able to object not only to that, but to relevance of the topics to be discussed. And there, As Your Honor has said, you've done some research. We have done research as well. I don't have those cases before me, but would be happy to provide them. I know of at least one federal case, and there's one out of North Carolina that adopted that theory.
All right. So the research I did on this issue, there is a Fourth Circuit case, United States versus Breckton, where the court addressed disallowed narrative testimony of a pro se defendant's trial. I didn't find any North Carolina cases on point, but there may well be. I think this is governed by Rule 611. I think it's the rule that allows the court to control the mode and order of interrogation in a case, and I think it is purely within the discretion of the court. My sense, Mr. Bradsher, is that the purpose for question and answer format in a courtroom is a laudable purpose. Namely, it allows the framing of the topic that's going to be given in response to that question. It allows an opportunity for an objection. It allows the opportunity for the court to rule on an objection before the evidence is stated. And so that's, I think, why overwhelming majorities of legal proceedings are done in a question-answer format. We do make an exception for pro se defendants, but in my experience, those exceptions are made when the defendants are entirely unschooled in law and procedure of a courtroom, because I think there it may well place an undue burden on a defendant to require them to propound questions to themselves and give a response. And I think the way that we control that in those sorts of matters is by very careful interjection by the court, guiding the testimony in terms of Rule 611, as well as frequent objections by counsel to make sure that a pro se defendant remains on track. But I'm not sure that that's an optimal situation either. My inclination is to require, if you do choose to testify, that you do so in the form of question and answer, that you would propound a question to yourself and then you would give a response to that question so that it would allow the same orderly format that we're accustomed to be observed. I think you certainly are a skilled advocate and have tried, as you've mentioned in the evidence, a number of cases. You certainly are in a position to craft those questions in a way that would lead to an orderly testimony. So I think in this case it would be appropriate to require that.
Yes, Your Honor, if I could just state for the record, I just simply, without much argument, object to that. I concede to the court. I've also researched. It is within your discretion. I simply make the point to the court that it does tend to punish, in a certain extent, someone representing themselves. There's a natural flow for a prosecutor or a defense attorney asking questions that aren't necessarily propounded by script, for example. And when someone is representing themselves, the narrative is a more natural flow of evidence to the jury as opposed to a defendant reading question and answer. Since it is unnatural, I do think it would affect the credibility of the witness just by the mere format. I know Your Honor may recall a hung jury in Person County on a child abuse case that Your Honor was sitting on, that the jury was hung, and we actually went through reading back portions of testimony from the transcript. And we did have people in roles for that purpose, so that the jury could hear the question and hear the answer from the transcript to create some type of natural flow. So I do think with that ruling that I would have to consider hiring counsel to do that type of examination to have an effect, substantive effect on the jury, as opposed to if I'm allowed to represent myself and testify by narrative, it would be a more natural flow to the jury. One other point I'll make and then I'll be quiet. And that is that to to propound a question and answer to the jury, forecast to the state and the court the flow of the direct evidence. And I would contend that the unskilled layperson who chooses to represent themselves is more likely to say something in the narrative form that's inadmissible or not governed by the rules of evidence, for example, whereas an attorney that has not only familiar with 28 years of trial work, but has also been directed by this court for the last couple of weeks on the rulings would be more adherent to the concerns you have of something coming out that's not objectionable. Simply state that for the record. I recognize the court's authority to make that ruling.
All right. And one clarification, I'm not sure that, perhaps you're assuming that I'm saying you need to propound questions in advance. I'm certainly not requiring that you provide either me or the state copies of questions that you're propounding. I'm simply saying that the testimony that you would give would be in the form of a question. You would state a question, and then you would give an answer. The order of those questions, and that's entirely up to you, and you would reveal them as you ask them of yourself. But that would be my ruling and in my discretion.
Yes, Your Honor.
All right. Let's go ahead and take then the 30-minute recess we referred to. We'll resume at 3:15, and we'll hear motions at that time.
Thank you, Your Honor.
Yes, Your Honor.